whatever the practice being followed in making appointment to the Chief Election Commission or the Election Commissioners under 324.
Yes.
He said there is no rules have been framed, the procedure has been laid down. We'll call upon them also for this purpose.
Yes.
But for the last more than 70 years, this practice being followed.
Yes.
Number of recommendations and all commission's report have increased for our perusal.
Yes.
But now our question to you is, what is the necessity has arose to individuals collectively or otherwise in approaching to this court or stepping down and lay down a principle as to what the government should follow in making an appointment?
I'll explain.
What we suggest is, but what is going to my mind?
Yes, yes.
If we take a cognizance on what you say today, whatever the practice being followed in making appointment to the Chief Election Commission or the Election Commissioners under 324.
Yes.
He said there is no rules have been framed, the procedure has been laid down. We'll call upon them also for this purpose.
Yes.
But for the last more than 70 years, this practice being followed.
Yes.
Number of recommendations and all commission's report have increased for our perusal.
Yes.
But now our question to you is, what is the necessity has arose to individuals collectively or otherwise in approaching to this court or stepping down and lay down a principle as to what the government should follow in making an appointment?
I'll explain.
What we suggest is, but what is going to my mind?
Yes, yes.
If we take a cognizance on what you say today, meaning thereby in the last 70 years more, the appointments which are made on this particular post, either the requirement of constitutional mandate has not been followed, or there's something wrong in the procedure, which we want to now correct, because somebody has approached to this court and calling upon to intervene, since the government is not coming out with a procedure as 324(2) contemplates.
Specifically with reference to insulating institutions. There's been a series of litigations, particularly in this court, over the last couple of decades. We have seen a lot of importance being given to three particular sets of institutions. Those three particular sets of institutions are the institutions which are the underpinnings of our democracy. This court has referred to them as being instrumental in sustaining the basic features of the Constitution. Absent those three, this Constitution and this democracy will collapse. The first of that is the judiciary, and your lordships have seen the efforts over the last 30 years, both as far as this court itself is concerned in institution building, in trying to create a system where there will be some independence, keeping independence of the judiciary at the core. There are only about 7 or 8 judgments of this court which have ever struck down a constitutional amendment. And they are only on 3 finite principles. The first is that there has been an exclusion of judicial review. So your lordships have struck down constitutional amendments on that ground. That's been the large chunk. The second has been on this independence of the judiciary. The NJSC judgment struck it down. And what was that independence of the judiciary that was being protected? The critics will say it was a wafer thin. It was 1 vote, essentially, on that committee. But it was enough for that wafer thin difference to create a situation which would imbalance the constitutional structure. That's the second. And the third, my lords, has been about 368 proviso not being complied with, a couple of judges, Yohoto and then this cooperative society. So, this is the importance that your lordships have given, particularly with reference to judiciary. The other principle that your lordships have sustained throughout, and this is why the other institution comes in, is of free and fair elections. In Indira Gandhi in 75, your lordship laid that down. And efforts since then have been on to try and strengthen the very body which will ensure that we have free and fair elections, which is the Election Commission. Those efforts have also been a tug of war. There have been efforts, my lords, to ensure that whatever yeoman service is provided by this court towards insulating the Election Commission, in ensuring that we have a clean and transparent electoral system, has been negated when governments have stepped in. Your lordship saw that, Mr. Bhushan alluded to it with reference to that ADR and PUCL cases. That was in fact a High Court judgment which was sustained in Association of Democratic Reform, saying that candidates must give affidavits which mentioned their criminal antecedents and mentioned their assets. When they implemented in law, they carefully forgot one part of the criminal antecedents and brought in only with reference to assets. So we had to have round 2. After which we've had round 3 in Public Interest Foundation. We've had round 4 as recently as last year. But now Lord Justice Nariman's bench went to the extent of saying, look, we're making it very clear. All you political parties on your websites, on your Twitter handles, on Facebook, you are going to put out the details of the individuals who have criminal antecedents that you are hosting as your representatives. You're going to give reasons why you have chosen that person if he has criminal antecedents as your candidate. And if you fail to upload this, and if you fail to give it publicity, the Election Commission is entitled to file a report in this court, in the Supreme Court of India, and it will be treated as contempt of court. That's the level to which this court has given attention to the importance of protecting that democratic system of ours. What Churchill referred to as a little man with a pencil walking into the booth. The reason
for your prayers.
Yes.
So I'm entertained by your
I'll explain what my prayers are. I'm supplementing Mr. Bhushan, Mr. Chowdhury on the first point. I have something else to say with reference to the appointment process.
We'll do that.
Yes, and now my 3 prayers.
Yeah.
The 3 prayers I'm pressing. Page 28. The 3 prayers. And I'll tell your lordships why I am pressing those. The first is with reference to the protection that has to be given to both the election. I don't think so, and I'll explain why. I'll explain, I'll make it good. I have gone through this provision many, many times, as one must. Every time we have to deal with a constitutional issue, reading it once is not enough. I've read it 20 times. I think there is a way for me to press this argument, which is the protection which is given to the Chief Election Commissioner is a protection that actually extends to both election commissioners. That is the first argument. The second is with reference to it having an independent secretariat. And the third is with reference to the expenditures of the Election Commission having to be a call on the consolidated fund, which is not a voted expenditure. The expenditure with reference to the Supreme Court judges, with reference to C&AG, with reference to UPSC, with our other constitutional authorities, are all unvoted administrative expense, which is important, which allows that even when a budget is going to be voted on, this will not be voted on. This is anyway an administrative expense to run the country, which has to go on its own. You can't subject the Election Commission's expenses, the salaries, emoluments of the Chief Election Commissioner and the Election Commissioners to a vote by Parliament. That can't be done. It has to be unvoted administrative expenditure, and this is not just me saying it. That counter affidavit I've shown you, Lordship. Chief Election Commissioner after Chief Election Commissioner with a begging bowl says, please ensure that these are changes that you will bring, both on the Secretariat as well as on the expenses to the consolidated fund.
And what is the third prayer?
That last one about conferring rule making, I am not pressing because I don't think that is necessary at all. That power exists. It's only a recognition, and that recognition
you're pressing only prayers A and B.
A and B.
A and B.
A and B. And D, I think, will cover even the appointment prayer. Anyway, made in the other 2 petitions. So I don't have to. So now, if I can,
you pick.
I should. Can I? I'm sorry, Your Lordship want me to start with that?
Yeah.
I'll start.
That's your prayer, because otherwise all the others are covered by various, you can.
No, I will repeat nothing. I just wanted, just before I address Your Lordship's on, I'll start with that prayer Your Lordship want me to. But just before that, I just wanted to complete my response to the Lord Justice Russell. So one was the Supreme Court and its judges, and the High Court and its judges, the independence of the judiciary. That's a very, very seriously important pillar. And thankfully today we have some level of insulation and protection. Some level, I still say. We have, of course, they will, at every point, we will find novel ways in which to frustrate the best of efforts. So when you don't need an IB report for a member of parliament, for an MLA, for the president, for the prime minister, for the CVC, for nothing. For judges, we suddenly need an IB report. So it's a novel way. They will find novel ways to keep coming and frustrating the best of efforts to create insulated positions for our most important institutions. So the judiciary is one. The second is the election commission. Because they uphold a basic feature which Your Lordships have recognized as a basic feature. And that's why, since Your Lordships wanted the citations, I'll give Your Lordship those citations. The basic feature citations, in addition to Indira Gandhi, which is 1975 supplementary SEC 1, Manoj Narula and Krishnamurti, I will refer to, which is Manoj Narula is 2014, 9 SEC, page 1, and Krishnamurti is 2015, 3 SEC, 467. Just on very, and I will take your lordship to paras, etc. later. I just want to briefly tell your lordship. Manoj Narula says that the core of democracy and of constitutional governance is this, of ensuring that you have an independent electoral process which is completely protected. Krishnamurti says that there is a vacuum in 324 and says that this free and fair elections, it reiterates once again about it being a basic feature of the Constitution. Now, these two large institutions, along with the third, which is the media, and that's why Article 19(1)(a), all the various protections Your Lordships have recognized coming out of 19(1)(a), the fact that we are always chary about making laws which restrict their speech, etc. These three are most important for the functioning of this democracy. Most important. Media itself is protected because to the large extent it is private, it's independent, it's not dependent on the government. But the other two, one has been given that level of insulation and protection, the other has not, which is the Election Commission. One tier below this, if you can imagine, one tier below this are independent investigating or superintendence agencies. The CVC, the CBI, and the ED. Your Lordships had to step in. ED less so, but CVC and CBI definitely. They have their own protections as far as the federal structure is concerned. So you need permission from the state if the CBI has to investigate Section 6 of the DSP Act. But when you appoint the CVC and when you appoint the CBI director, you make advertence to a committee, and it's identical committees in both cases. A committee which consists of the Prime Minister, the leader of the opposition or of the single largest party, and of the Chief Justice of India. That committee of three is what I would suggest to Your Lordships can be adopted equally for this purpose also. It is independent, it appears balanced, and like Your Lordship said, every institution, eventually there won't be a perfect system. But you will have to look at what precedent we ourselves have set. Now, keeping these parameters in view, and these parameters in my view are important for all my issues.
Before you proceed further,
yes,
just have a clearing of a certain idea. I mean,
yes.
See, when the Chief Justice,
yes,
let's assume that we accept your prayer.
Yes.
Yeah?
Yes.
And the Chief Justice is a member of the collegium.
Yes.
As we call it, or whatever the committee you call it.
Yes.
Yeah?
Committee, it will be selection committee.
It's a committee.
Yes.
The Chief Justice is there, leader of the opposition is there, and the
Prime Minister.
Yeah. Now, so what is the procedure that is usually adopted? For example, in the case of CBI,
Yes.
usually it will be from the Indian Police Service
Yes. That's in the statute.
in the statute.
In the statute, they provide for the qualifications, eligibility, report.
Everything.
It's all there.
In
Yes.
the case of the election commission and the chief election commission,
Yes.
it's usually drawn from the IAS officers.
Yes.
No, what is the objective material they'll go by? They'll go by the confidential report.
ACR. Yes.
ACR. ACR for the whole of their lifetime,
Correct.
they get outstanding.
Correct.
So that there'll be a giving of the marks and some basically
Yes.
excellent officer,
Yes.
honest. There'll be the,
Yes.
will it have anything to do with this definite political leaning? Because ultimately, the man may be completely honest,
Yes.
every which way,
Yes.
financially honest.
Yes.
But when it comes to his political leaning, we're just posing this.
Yes. Yes. No, I agree. I agree. I agree.
Whether, this meeting of minds of these three dignitaries,
Yes.
we have mentioned,
Yes.
Chief Justice.
Yes.
Because we don't know how it happens.
Correct.
Meetings, normally we take, when we also have these meetings, we go to the ACR,
Correct.
there is a good officer,
Correct.
that's all.
Yes.
Will it be sufficient to ensure that, it is elected as it is appointed as a chief election commissioner or the election commissioner, that he will not end up displaying complete political bias?
No, absolutely no assurance of that. And there can't be. We don't have that assurance even from the Supreme Court's collegium. We don't have it from any of these committees that we have for CBI directors, CVC. Your Lordships have seen the number of petitions we find day in and day out against a CVC. Or, in fact, in the CVC case, your Lordship will remember that CVC Thomas, when he was appointed, I was with Mr. Venugopal appearing for the CVC.
We remember that.
So, no, but I'm glad your Lordship mentioned that, because it brings up that additional point that your Lordships evolved in that case, in that Center for Public Interest Litigation case, which was institutional integrity.
Because this proficiency, competence
Yes.
is not necessarily to be conflicted.
No, it's
with,
suitability that your Lordships are at. Because,
conflicted with independence.
no, it can't. It
See,
can't.
the
So,
point is-
eligibility
Yes,
is,
the reason
Yes.
why a Supreme Court judge
yes,
is able to do the things
Yes.
he is able to do,
yes,
in fact, in the law is that he is insulated from the doctrine of pressure,
yes,
under the shadow of which the government servant operates.
that's true.
Because that's
Absolutely. Yes,
Supreme Court judge cannot be thrown out there.
yes,
If they want to,
Yes.
even if they want to.
yes,
It's an elaborate procedure.
correct.
So that is something which may not have anything to do with his competence.
Yes.
You may have a competence, you may have a need.
No,
As
yes,
Dr. Ambedkar said.
absolutely.
So that is the area, where we are a little,
No, so which is why, my lords, every time, your Lordships are better placed than I am. Every time your Lordships have been on interview committees to appoint judges, for example, your Lordships will have the basic parameter of eligibility, which are the basic qualifications, etc. But above that, there will be discretion which you will have, whether you put it down as a procedure which you must look at, or whether you don't.